Recording 9, Sales of Good Act 1957. Kita tak payah beritahu kan, kita beli kereta mesti lampu tu mestilah boleh bernyala kan atas kepala kita di dalam kereta. Tetapi bila kita beli kereta, tiba-tiba lampu dalam kereta sebagai contohnya tak bernyala, itu adalah pelanggaran warranty. Dia pelanggaran waranti, iaitu stipulasi yang bersampingan kepada tujuan utama kita membeli barang. Sebab biasanya tujuan utama kita beli barang adalah untuk mendapatkan kereta yang boleh jalan, yang tidak rosak enjin. Jadi kalau mengikut pendapat hakim, ini adalah pelanggaran waranti, maka ianya menjadi pelanggaran waranti, di mana kemungkinan pelanggaran waranti, breach of implied warranty, hanya memberi buyer the right to get damages sahaja dalam bentuk ganti rugi. Okey, dapat ganti rugi je, tapi tak bolehlah cancel the contract, repudiate the contract, terminate the contract, hantar balik kereta, minta balik purchase price, minta balik damages, etc. Tak boleh. Tetapi ada juga dalam certain cases di mana hakim akan kata, kereta, lampu dalam kereta tu pun adalah sebab sebenar kamu beli kereta. Tujuan utama beli kereta. Sebab bila orang beli kereta, dia nak semuanya lengkap. Okey, semuanya perfect semuanya. Kalau hakim berfikiran gitu, that means this is a breach of implied condition and not a breach of implied warranty. So it depends. So look at your PowerPoint again yang Madam dah hantar just now. That is section 12, subsection 3. After this, Madam nak pergi bank sekejap. Madam balik, today, tak tahulah pukul 1 ke pukul 12 tengah hari. And Madam akan sambung this sale of goods tak banyak. Maybe just 3 or 4 recording. Madam want to speak in detail pasal breach of implied condition bersama kes-kes yang relevan dan juga breach of implied warranty bersama kes-kes yang relevan, maka habislah bab ini. Madam bukan mengajar pendek-pendek tau bab ni. Memang inilah yang Madam mengajar sebelum-sebelum ni pun semester. Ya, Madam tak bocorkan apa-apa. Madam cakap sekali lagi ni sebab Madam bimbang nanti, if recording suara ni pergi ke FKP, kamu pula bagi kat student yang bukan student Madam. Jangan bagi kat student bukan student Madam, menyusahkan kita je. Menyusahkan Madam, menyusahkan kamu. Do you understand? It's only for you. Kau tidak disalah ertikan. Nanti FKP kata Madam bocorkan soalan. Padahal nothing to do with the soalan. Madam tak boleh buat apa-apa. It's not my soalan pun. My job is only to teach. Since I cannot meet you, I can only record my voice. Madam memang sedih pasal ni dengan suara ayam Madam lagi yang non-stop berbunyi sebab dia bunyi suara Madam dari dalam rumah. Itu sebabnya. Dia bunyi manja. Ayam pun dah manja, dia pun start bersuara. So, I'm very sorry. So, tunggu ya. You buatlah revision kamu yang Madam dah record, and before that Google Meet apa semua tu, tolonglah do something. Your exam is next week on Tuesday. Jangan panik, just ikut apa yang Madam suruh buat. Itu sahaja. Recording number 10, Sale of Goods Act 1957. Yesterday we spoken about implied conditions and implied warranty. Now Madam want to go one by one. Okay, so number 1, Madam would like to cover section 16, Sale of Goods Act 1957. It says that goods must be reasonably fit for purposes the buyer bought the good for. Maksudnya dalam bahasa Malaysia, syarat tersirat yang ada dalam akta ialah barangan itu kenalah sama bagi tujuan pembeli membelinya, ataupun barangan itu mestilah berpadanan dengan tujuan barangan itu dibeli. Barangan itu mestilah berpadanan. Barangan itu mestilah berpadanan dengan tujuan pembeli membeli barangan. Jadi macam mana kita tahu sama ada penjual telah memungkiri syarat Seksyen 16. Jikalau dia memungkiri syarat Seksyen 16, itu adalah breach of implied condition. Maka pembeli boleh membatalkan perjanjian, maknanya repudiate atau cancel atau terminate the contract. Pembeli boleh return the goods, pembeli boleh ask for the purchase price back, pembeli must return the good that dia dah dapat, pembeli can ask for damages and also all related damages. Macam mana kita nak tahu, Dik? Kita boleh tahu jikalau pembeli itu sudah memberitahu penjual kenapa dia nak beli barang. Maknanya pembeli go to the seller and tell the seller why I want the goods. For example, pembeli kata I want to have a nice skin, or I have acne, saya ada banyak jerawat, maka saya tak happy. You know, this and that. Itu adalah memberitahu tujuan. The purpose the buyer wants the good, atau the purpose the buyer want to buy the good. Dia dah beritahu. Maka jika penjual beri obat ke barang kepada pembeli tetapi tidak memenuhi tujuan kenapa pembeli membeli barangan tersebut, maka pembeli boleh membatalkan perjanjian sales contract ini. She can reject the good, ask for price money back, she can terminate the sales contract, she can ask for damages, but she must return the drug ataupun medicine itu. Betul tak? That is the story. So Madam want to tell you about two cases. Number one is Griffith, GRIFFITHS versus Peter Conway, PETERCONWAY. Kamu mesti Google kes ni. Tak payah hafal, sekurang-kurangnya buat nota. Basically, this lady pergi beli one coat, okay? Satu coat, tetapi tidak memberitahu the seller dia sangat alergi kepada wool, WOOL, okay? Bulu binatang. Lepas tu bila dia pakai coat tu memang ada bulu binatang, she spend thousands of money with the skin doctor, with the doktor specialist untuk kulit. Dia pun menyamanlah penjual. You know, she terminate the sales contract. She want to return the coat back to the seller. She ask for damages tu yang sangat pentingnya, sebab dia akan, bila kita minta ganti rugi, damages beribu-ribu atau beratus ribu. Okay, but it was held by the court that the lady failed in her summons in court because she never told the seller the reason why she wanted the coat. So according to the law, if she didn't say anything about her skin condition, she's considered like everybody else in society. She's a normal person. So a normal person who wear the wool coat will not experience any skin problem. So she failed to reject the goods. She failed to repudiate or cancel or terminate the contract. So the conclusion in that case is there is no breach of Section 16, that goods must be reasonably fit for the purpose the buyer bought the good for. There's no breach. So the seller selamat dalam kes itu. No problem for the seller at all. Buyer saja yang rugi. Whereas in the case of Grant, GRANT, Grant versus Australian Knitting, KNITTING, Mills, MILLS, Grant versus Australian Knitting Mills. Lelaki ini, pergi kepada satu kedai, mahu membeli thermal, THERMAL, thermal underwear. Makna seluar dalam lelaki yang dapat memanaskan badannya sebab masa tu musim sejuk. Overseas, when it's winter time, normally we have a thermal underwear. Maknanya pakaian dalam, camisole ke apa, semua tu kita panggil underwear. Tapi dalam masalah ini, underwear dia tu memang seluar dalam lah. Tapi dia dah beritahu Mr. Grant tu dah beritahu bahawasanya dia sangat allergic, allergic, to wool. Dia allergic. Tetapi seller tu dah tahu dah, Mr. Grant cakap dia allergic to wool, dia bagi juga underwear made of wool. After that, Mr. Grant suffered serious skin condition, eczema, eczema, and then he terminate atau repudiate the sales contract with the seller. He wanted to return the underwear. I pun tak tahulah whether the seller nak ambil balik ke tak. But in theory memang boleh return because dia nak terminate the sales contract. So when it goes to court, the court says that the buyer already told the seller about his skin condition, allergic to wool, so he has disclosed, disclosed, ataupun he has told or he has declared about his skin condition. So the seller was in breach of the section 16 that goods must be reasonably fit for the purpose the buyer bought the goods. So in that case, the thermal underwear was not fit for the purpose Mr. Grant bought the thermal underwear for. Recording 10, Sale of Goods Act 1957. So basically these two cases. And Madam want to refer to Priest versus Last. Basically, according to Section 16, Section 16 says the buyer must let the seller knows why he wanted the goods. But in most of the cases, the buyer need not say anything. Tetapi still, jikalau lah tujuan dia beli barang tu semua orang tahu. Kalau beli susu untuk minum susu, betul tak? Kalau beli kereta Proton, to get enjoyment from driving the car. So tak payahlah cakap kenapa kita beli Proton. You nak cakap ke kepada orang jual kereta, saya beli kereta kerana saya nak enjoy driving the car? You beritahu tak? Kalau you beritahu, orang kata kita gila. You beritahu tak orang kat 7-Eleven, saya beli susu hari ni supaya saya boleh minum susu, ataupun saya beli susu sebab saya suka minum susu, ataupun saya beli susu supaya saya dapat. Jadi, what I want you to know is, walaupun the buyer most of the time tak beritahu seller kenapa dia beli barang, betul tak? Kenapa dia beli milk, susu tepung, gula. Kalau tak, orang kata kita gila kan. Walaupun dia tak beritahu, jikalau dia bagi gula kat kita yang sudah rosak, atau dibagi kita susu tepung yang sudah rosak, boleh tak kita reject the goods, we terminate the sales contract, we ask for money back, we ask for damages, sebab we can do all this sebab we say the seller has breached section 16 implied condition that goods must be reasonably fit for purpose the buyer bought the good for? Boleh tak? Of course boleh. The buyer can say the seller has breached implied condition section 16 even though the buyer never say why he bought the goods. Walaupun condition under section 16 memberitahu bahawasanya under section 16 you can only sue the seller if the buyer tells the seller why he bought the good. But according to common law cases, in Priest versus Last, that is the first case. After that, it was stated again or discussed again in Griffith Peter Conway, and then in Grand Australian Intimates and many cases in the Commonwealth country. Tak payah. If the purpose why we buy the goods, everybody knows already. So we can only tell the seller, if the purpose we buy the good people do not know. For example, we have a bad skin condition, we allergic to Panadol. So kalau kita beli obat, we make sure tell the seller don't give me Panadol, bagi saya aspirin, ataupun jangan bagi obat ada paracetamol dalam tu walaupun 1%. Kena beritahu. Barulah we can sue them under breach of section 16. If you read the two cases tu, Grant dan juga Peter, dua-dua kes tu sectionnya bukan section 16, because section 16 yang kita cakap ni is in Malaysia. Tetapi section yang Mak Saleh punya, kalau tak silap saya 14, ada yang 15. Tapi kita ikut sebiji mereka punya di Australia dan di Britain. Cuma section saja yang berubah, nombor section saja yang berubah. But about fitness for purpose dan lain-lain, semuanya sama. Boleh? Thank you. Recording 13, sale of goods at 1957. So according to Priest versus Last, there was a discussion among the judges, discussion among the hakim-hakim in that case, that if the good that we want to buy has an ordinary and normal meaning among the public, we don't have to tell the seller why, or we don't have to tell the seller the reason we bought the goods. So if the goods yang dijual pada kita tu rosak ke, cacat ke apa, we can still have legal recourse. RECOURSE makna boleh dapat legal punya defend untuk kita kembali from mahkamah, that we can sue the seller for breaching the implied condition of the Malaysian section 16. Okay, so dalam kes Priest versus Last tu, dia beli hot water bottle. Isteri dia zaman dulu Mak Saleh ada hot water bottle, zaman mak saya pun, kita boleh taruh air panas dalam tu. Lepas tu bila taruh air panas, satu hari bila dibuka, if I not mistaken, hot water bottle tu meletup. And then bila dia meletup, habis, kalau tak silap saya, suami yang cedera, bukan isteri. So cacatlah wajah dia kerana dia meletup atas wajah suaminya. Jadi mereka pun menyaman saya lupa, dia menyaman penjual hot water bottle ataupun manufacturer hot water bottle. And then di dalam kes tu, lawyer sebelah penjual ataupun manufacturer hot water bottle kata si suami datang beli hot water bottle, tak pernah beritahu why he bought the hot water bottle for. Dia kena beritahu lah, baru boleh saman for breach of implied condition under the relevant section 16 yang Malaysia punya. Mak Saleh punya relevant section 14 kalau saya tak silap. But hakim-hakim discuss and they say no need to say the purpose why we buy the goods under normal condition if the goods tu have already a normal and ordinary usage and or meaning to the general public or society. Kalau semua orang dah tahu kenapa kita beli hot water bottle, untuk simpan panas lah, kenapa nak beritahu lagi? So in the end, the husband and wife tu, they won WON the case for breach or implied condition against the seller ataupun manufacturer. You can check if you have time, otherwise you just depend on my lecture. That's all, because you bukan law student. Okay, thank you. Recording number 14, sale of goods at 1957. Satu lagi, kalau kita pergi beli barang, let's say refrigerator ke, kalaulah penjual tu pula yang bercakap apa-apa kepada kita, kita mungkin beritahu, tetapi dia pula yang beritahu, betul tak? So kadang-kadang kita boleh menyaman penjual di atas 2 atau 3 atau 4 atau 5 kesalahan ataupun 5 kesalahan breach or implied condition against the seller. So kita as a lawyer, we have to know. So another implied condition yang telah termaktub di dalam Sale of Goods Act Malaysian punya is section 15, bahawasanya there is an implied condition bahawa goods must correspond with the description by the seller. So kalaulah kita pergi cakap nak beli peti sejuk yang nanoteknologi, and then dia pun cakap, yes, inilah nanoteknologinya. Dia cakap, ini peti sejuk Hitachi, bla bla bla, harga RM2,000. Bila beli, rupanya bukan pun nano model yang sebelum itu. Can you repudiate atau terminate or cancel the sales contract with the seller? Yes, this is a breach of implied condition section 15 that the goods must correspond with the description made by the seller. So description tu dek, you kena buat nota. Apa maknanya? Description tu when the seller says orally, makna secara lisan, itu description, makna dia bagi maklumat. Or there is a notice, pasted on the refrigerator ke, notice pasted, on the cover of the paracetamol Panadol ke, that is all description. Ataupun notice, brochure ke, the seller gave to us, that is description. Kalau semua ni berlaku, that is a breach of section 15. So, description ni adalah kenyataan yang diberi oleh penjual. Kenyataan ini boleh secara lisan atau bertulis, ataupun brochure, ataupun apa-apa yang ditulis atas peti sejuk tu ke, cover Panadol ke, cover obat ke, etc., ataupun iklan. That is description. So the case on point tu, kalau you nak baca pun boleh. Yang paling senang bagi saya, Bill versus Taylor, B-E-A-L-E versus T-A-Y-L-O-R, pasal lastik, catapult. Lastik tu tiba-tiba dibeli, lepas tu pak saudara beli ke budak tu sendiri yang beli, tiba-tiba dia tarik lastik. Sepatutnya batu tu pergi ke depan, ni tak, batu tu pergi ke belakang, mata dia yang jadi buta, if I'm not mistaken. So dia nak saman for breach of implied condition lah, yang Mak Saleh punya relevant section, tapi kita punya section 15, and dia menang, if I'm not mistaken, because penjual tu cakap, this is the best catapult lah, etc., is the correct catapult, maknanya correct lastik. Tiba-tiba apa yang jadi, betul tak? And you think why dia nak saman bawah ni, pak saudara dia ke, ayah dia ke, saya dah lupa, you baca sendiri. Dia nak saman because kalau kita repudiate kontrak saja, itu tak ada benda kan. Kalau kita minta duit balik pun tak ada benda kan. Harga catapult tu mungkin hanya RM10 duit kita. Yang paling penting dalam case sale of goods contract ni, kita nak repudiate sales of goods contract because we want to get damages. Damages can run into millions. So if we go back to the case of Grand Australianity Miss dan juga Griffith Peter Conway tu, dalam kes Griffith Peter Conway dia kalah kan, sebab dia tak beritahu niat sebenar dia beli barang. Kalaulah niat sebenar dia beli barang tu normal, sebab dia mempunyai kulit normal, tak apa. Tak masalahnya dia kena beritahu sebab dia ada penyakit kulit yang serius, orang biasa tak ada, because dia nak repudiate the contract. Tetapi dalam kes Grant versus Australianity Miss, dia beritahu kenapa dia nak beli thermal underwear. Dia cakap dia tak nak thermal underwear yang ada wool, tapi dibagi wool, and then lepas tu sakitlah dia. So in the end dia menang. So if you want to know, kita orang like madam ni as a commercial lawyer atau business lawyer, kes-kes macam ni kita bukannya boleh saman seller hanya for breach of implied condition section 16, but fitness for purpose, but we can also saman the seller for breach of implied condition section 15, that good must correspond with description. Kita tengok dulu fakta kes tu. Biasanya kalau seller tu bercakap-cakap, dia bagi benda yang salah dan kita pun cedera lah, maka itu pun breach of section 15 juga. Okay, so I hope you got it. So dalam satu kes, banyak weapon that we can bring against the seller. Thank you. Recording number 16. Sale of Goods Act 1957. Another implied condition is goods must be of merchantable quality. Maknanya implied condition ni ialah barangan mesti ada kualiti dagangan. Yang Madam tahu, there's no section under the Sale of Goods Act yang Mak Saleh atau Malaysia punya. Ini come direct from case law, from the common law. Cuma you have to know, kalaulah kita beli kereta tiba-tiba terus aja rosak, betul tak? Adakah barangan tu ada kualiti boleh dagang? Maknanya kita beli kereta hari ni 40,000, esokkan hari ataupun 2 bulan lagi dah rosak shock absorber maknanya. Adakah kita boleh jual balik pada harga 40,000? Katakan keesokan hari, sepatutnya boleh jual lagi 40,000 kan? Ataupun seminggu lagi. Tak boleh dah. Sebab kalau orang tahu shock absorber tu dah berapa ribu, dek. Sekarang maybe dah campur semua ada kot dekat 4,000. Orang tak akan beli pada harga yang 40,000 ataupun turunkan sikit you tolak 4,000 jadi 36, kan tak nak pun. Kereta tu baru mentah dah rosak dah. So people will think ada lagi rosak yang lain, hidden defects, DEFECTS. So dalam kes tu grant or solemnity miss tu, kita boleh saman juga the seller for terma underwear dia breach the implied condition that good must be of merchantable quality. That means the terma underwear sold to Mr. Grant has no merchantable quality. So kita ada banyak senjata, to go against the seller. Madam and then Madam tak bagilah apa-apa kes tu. Memang ada dalam common law, but you boleh check sini kalau you terlampau rajin lah, but we don't have time anymore. Okay, thank you. Recording 17, implied condition that sale by sample, implied condition that whenever there is a sale by sample, that sample must correspond with the sample given by the seller to the buyer. Okay, so that is our Malaysian section 17. Tapi Mak Saleh Australia section lain, and in Britain section lain, but apa yang dia tulis tu almost 100% sama. So the case on point again ada 3 tu, Drummond, Wen Engine, Godly Perry, Lau Yao Sing, semua tu. Kalau saya hafal Godly Perry pun dah boleh dah. Tapi Madam tak boleh beritahu apa yang keluar dalam exam pun. Cuma nasib baik objektif. Okay, itu sahaja. Jadi kalau kita refer back to the case of grant or solemnity mills tu, ada sale by sample tak? Ada. Because in that case, seller tu dah tunjuk terma underwear tu. Dia cakap tak ada wool. Okay, so dia dah breach implied condition of sale by sample. Because implied condition cakap sample used by the seller must be sama dengan apa yang ditunjuk, apa yang diberitahu lah. Dia kata sampel ni tak ada wool, tapi sampel yang diterjual tu ada wool pula. Mana satu ni? So we don't care mana satu, but bottom line, he has breached the sale by sample. Janji dia tunjuk barang tu sampel, tak kisah dia tertukar ke apa, dia pernah tunjuk barang. So kalau you pergi beli peti sejuk, and peti sejuk tu dia kata nanoteknologi kan, ada sampel depan mata, tak perlu ada tulisan. Dia kata ni lah peti sejuknya. Okey, ataupun penjual tak cakap apa, sampel tu ada kat depan, ada notis lagi. So it's a breach of sample lagi, it's a breach of description lagi, it's a breach of merchantability lagi, it's a breach of fitness for purpose lagi, semua all in. Recording 18, implied condition section 14 subsection A huruf kecil, that whenever the seller sell the goods, there is an implied condition that the seller can have the good legal title to transfer the good legal title to the buyer. So dalam section ni tidak berkenaan lah dalam kes-kes jual obat ke, jual terma underwear ke, jual kot ke, biasanya kecuali lah barang-barangan tu semua harta kecurian. So dalam kes ni biasanya kes melibatkan barang curi like kereta. Bila kita beli barang curi, kita dapat tahu we want to repudiate atau we want to cancel or terminate the sales contract so that kita hantar balik kereta tu, betul tak? Ataupun kita hantar balik gelang tangan tu, rantai emas tu, sebab ni barang curi, kita tak nak kan, nanti polis datang cari kita juga. So we can use that section to go against the seller, to sue the seller. Okay, so nanti Madam cari nama case, kalau tak silap saya Roland versus Dival, ROWLAND versus Dival, DIVALL ke DIVAL. Nanti Madam confirmnya whether correct or not that case. So basically, according to this section again, there is an implied condition under section 14 subsection A huruf kecil that the seller has the right to sell the goods when at the time property is to pass to the buyer. Maknanya ada syarat tersirat bahawasanya penjual ada hak untuk menukarkan hak milik barangan, ada hak untuk menukar hak milik barangan yang baik ataupun yang bagus kepada penjual pada masa hak milik barangan boleh bertukar. Maknanya bila masa hak milik barangan akan bertukar kepada seller. Dalam bracket mana bila dia bayar duit lah, ataupun as per the agreement. Okay. Recording 19, Sale of Goods Act 1957. Now, Madam want to speak about implied warranties. Implied warranty ni, we know already, the breach of implied warranty can only give the buyer the right to get damages only. Okay, so Madam just want to speak about section 14, subsection B huruf kecil. Warranty of quiet possession. Quiet, Q-U-I-E-T, possession, P-O-S-S-E-S-S-I-O-N. And also section 14, subsection dalam bracket C huruf kecil, close bracket, warranty that goods are free from undeclared charges and encumbrances. ENCUMBRANCES. No, so the first one, Section 14, subsection A, it means there is an implied warranty that the buyer, when he bought the goods, he must enjoy quiet possession of the goods. That means seller cannot disturb the buyer anymore after the seller has sold the property to the buyer. For example, the buyer buy a Jaguar, lepas tu there's a car exhibition in KB Mall, and the seller says, can I borrow, pinjam, the Jaguar sekejap for 3 days to put at the car expo in KB Mall. So bila seller buat macam tu, the buyer can sue the seller for breach of implied warranty that the seller cannot disturb the buyer the moment the buyer already bought the goods. Kalau seller disturb juga, ganggu pemilikan aman pembeli di dalam barangannya, maka pembeli boleh menyaman penjual di bawah kemungkinan section 14 section A huruf kecil tutup bracket bahawasanya penjual telah memungkiri section 14 section A. Maka penjual mesti memberi pampasan, ganti rugi, damages. So must remember only damages, but the contract of sale is not cancelled. It's not repudiated. Okay. And regarding the last one under this chapter, it's the same that Madam mengajar sen-sen lepas pun, section 14 subsection C huruf kecil. You know, when we sell things to the buyer, the barangan itu cannot have hidden charges, okay, ataupun sekatan-sekatan charges, CHARGEC, or encumbrances, ENCUMBRANCES. Encumbrances ni maknanya charge jugalah, tapi bahasa Inggeris. Contohnya, if Madam Malina sells to the class rep my car. After class rep Pova bought my car. After that Pova terkejut. Kereta saya banyak saman polis and also saman JPJ. You know, police summons and also JPJ summon because saya suka bawa kereta laju-laju. These are hidden charges and encumbrances. So, Pova can sue me for breach of implied warranty, section 14, subsection C, huruf kecil. Ataupun kita jual apa-apa, barangan itu sebenarnya dia pernah gadai dan masih tergadai di bank, for example. Okay. So, to recap balik, revision for this chapter, remember, when the buyer buys something, he or she not happy, he or she can have many charges. Okay, kita nak saman dia bawah many implied condition or implied warranty. So, must check back the facts of the case. Kadang-kadang kita hanya ada satu senjata to go against the seller. Kadang-kadang dua, kadang-kadang all of them. Okay, so we must read the facts of the case carefully. Okay, so satu lagi, all these implied condition and warranties ni are in section 14 to section 17. 14 to 17. So we must remember, when we have a case, you know the issue is what? Whether, apa dia? Kalau kita ada case, kalau soalan tu tanya, what is the issue or the question? The issue is what? The issue is whether the buyer can sue the seller for breach of implied condition or breach of implied warranty, etc. etc. Itulah maknanya. Thank you. So now, madam, we sambung later for the law of agency. After that, we go to law of contract. Tak banyak dah, and we do revision for law of contract. Thank you.